which is said that these laws shall work according to the law and international law. Based on this law and cooperation, which is partly categorized as part of the norm of the accepted international law, has become the foundation and the source that the courts in Serbia can resort to in order to implement the statute of the ICTY. In continuing the harmonization of our legal structure with the ICTY and the international criminal law, whatever you would like to call it, adopted a series of regulations that precisely provide for that. We adopted a law on the protection of participants in the proceedings, which is particularly important for the protection of witnesses, injured parties, even expert witness who enjoy protection in criminal proceedings. This is all done in order to provide a more efficacious processing of war crimes. A new criminal law was also adopted, which introduced some new crimes that were not to such an extent encompassed by the former criminal law, including crimes against humanity and the infamous command responsibility, which is failure to prevent the commission of crimes against humanity, which is envisaged in Article 384. We also adopted some other laws, such as law on international legal aid, etc. All of this was for the purpose of providing a better cooperation and a more effective processing of war crimes. In a certain way, the source of this is the ICTY. For example, in the then Belgrade District Court, we virtually copied the work of the Unit for Assistance of Victims and Witnesses of the Tribunal, and it has been in operation for 4 years now. All these legal frames are greatly helpful in the operation of the Belgrade District Court and other judiciary institutions, but I'm sure that the prosecutor's office is going to say more about this. On the other hand, we have achieved a better cooperation with the countries in the region, because these countries as well have turned this theory into very specific, concrete results.
Thank you very much for your comments, and we see the impact the existence of the tribunal had on legislation in your country. President Havatin, in Croatia, has there been a similar impact on legislation?
Hvala. Ja ću u ovom svom uvodnom dijelu intervencije odgovoriti svakako na vaše pitanje.
Thank you very much. In my introductory remarks, I am going to respond to the question that you put. However, I believe that this gathering also merits a legal philosophical approach. And after all, Judge Creso ended on a particular note that I would like to start on, namely what was discussed yesterday, crimes. And colloquially, I'm going to call them now simply war crimes. And they are very serious, as we heard yesterday. They're grave, serious crimes. And I don't think that none of us here should be discouraged by the reactions that we heard yesterday. We heard the voice of the victims who are pleading for justice, appealing for justice. They cannot really speak in that way. Others have to speak on their behalf because of the responsibility involved, because of the gravity of the crimes involved. We need to hear something here, namely, if victims who can no longer speak were to ask for justice, they would ask even more. So it is a question of who the perpetrators were as well, but this is a profound question. That is why we as courts have to deal with this. That is what I wish to say in my introductory remarks. We have to try crimes like that. Then you're also going to ask me why I'm starting with the independence of the judiciary. I'm simply trying to tell you where Croatia was in the past and where it is today, where Croatian courts are today and where Croatian courts want to be tomorrow, and where Croatia as a country wants to be tomorrow. If there is a legal and philosophical question that needs to be put, and perhaps it can seem a bit too scholarly, we should see who is the judge dealing with crimes. Is that someone who should be between the community and the state, or should that judge be part of the state or directly representing the community? We see here that individuals are placed before judges, and judges have to stand between the state on the one hand and the individual who is being tried on the other hand. That is the core of independence of the judiciary. Otherwise, there can be no fair trials, and that is what we need in war crimes trials the most. Our trials are in their very inception, and we cooperate with non-governmental organizations, and we see what evaluators said. I mean, NGOs also call this the early 1990s, and then the situation was not good. Why is it so? Because there was this lack of independence. Perhaps it wasn't that much pressure that came from the state, but then there was the public that distinguished between different types of victims and people who were being brought to trial and ultimately judged. The trials were not conducted as they should have. The defense was not good. It was not appropriate. There were judgments that were passed without the defense appealing. That needed to be rectified precisely through this independent judiciary that we were building all this time. And I believe what Mr. Degel said a few words about that through a great deal of legal activity, educational activity, and various other measures that we took, we can now say that war crimes are being tried in Croatia impartially and independently today, but professionally, which is also very important. Also, we have been developing our existing legislation, and we relied on the jurisprudence of the International Tribunal in The Hague as well. That was important for us. But when I'm speaking about the judiciary, again, I'm going back to the question of independence. The relationship between the Croatian court and the International Tribunal cannot be the same like the relationship between the office of the prosecutor of the Tribunal and the Croatian prosecutors and other prosecutors in the region. The prosecutor in Croatia has a different role, and then we also look at the evidence as it is brought here and as it is brought forth in Croatia. However, we developed our own criminal law to the extent to which it was supposed to increase efficiency. But I would also like to point out a few other things, namely, all criminal proceedings have to be carried out professionally by independent and impartial judges. I'm not saying anything else. However, I would like to refer to something else that was said during the previous session. In fact, there should be a presumption of innocence, and that is very difficult, especially with such grave crimes that we're discussing now. But also there should be full respect for the protection of witnesses, but also for the injured parties involved in these crimes. We have provided the right kind of framework for that. We in Croatia established a certain system of protecting witnesses and injured parties as such. These are systems of support to them. That is an institute that we have been referring to in Bosnia and in Serbia and in Croatia, because that would probably have happened in terms of general development anyway, even if there had not been all the unfortunate things that happened in this part of the world. So I agree with the previous panel that said that many institutes were introduced bearing in mind the case law of this tribunal, the practice of this tribunal, and that was then taken on by our own judiciaries. Mr. Degel spoke about video links, for instance, that are customary today and make it possible for us to carry out trials efficiently. Also, there is inter-court communication and cooperation, not only in this region, but also beyond. For example, in Vukovar, Split, Zagreb, and Rijeka, the county courts had such proceedings of this kind with Republika Srpska, Bosnia and Herzegovina, Norway as well. So this is something that has been taken on and adopted as a tool in our work. I repeat, there is witness protection as well. However, what I consider to be the most important achievement is this independence that is reflected in the possibility of Croatian judges to fend off the requests that are sometimes voiced by the public or international pressure, if you will. Let's be frank about that too, that call for a certain type of punishment or a certain type of decision. I wish to believe deeply that that is no longer possible in Croatia. Any court can make a mistake. This court, other courts. But these mistakes leave a profound impact even after they're rectified. Even in appeals proceedings, they can leave a lack of confidence. They can leave a feeling that courts are not impartial. I'll give you a case from Croatia, the Lora proceedings in Split. During the appeals phase, it had the fate that it was supposed to have in the first place. But for years, people are going to go on talking about that trial and those proceedings. I'm never going to object to that judge as to how he tried his case. As far as his decision is concerned, that is his legitimate right, and it is for his chamber to assess the evidence. However, I am going to object to him because he did not carry it out legia artis, and he did not show impartiality in each and every stage of the proceedings. Those are the mistakes I'm talking about. We have to be aware of these mistakes, and we have to know how to redress such a situation. Speaking of mistakes, I think that Croatia paid a very serious price in the international field because of the mistakes that were made, but also internally. It's the internal plane that pains me more. As far as the international situation is concerned, that's obvious. We would like to see Croatia in the European Union as soon as possible. However, the mistakes that remain in the country itself, among the people themselves, that is what is even more serious. We heard of some of the repercussions yesterday as well. Therefore, in my introductory remarks, I wish to point out where we were, where we are now, and in which direction we wish to move, namely, to develop cooperation increasingly with countries in the region wherever possible, not only in the field of war crimes, let me call them that again, but in terms of crime in general in the region. Crime is organized in the region, but it's courts that are lacking behind. Prosecutors' offices in the region are ahead of courts in terms of mutual cooperation in the region. I believe that we as courts, through international legal assistance and cooperation, will be able to advance further. I'd like to mention another thing that was not mentioned until now in the context of courts, that is NGOs. In Croatia, at first, NGOs were the correctional mechanism that was necessary. They monitored the proceedings involved. They were cautioning against mistakes. They were warning of mistakes. They were very loud in this. Their voice was heard, and they indeed helped us, because it is through these checks of theirs, they made the voice of the public heard, so that what could be corrected was corrected. NGOs have the same role today as well. However, I believe, at least on the basis of the reports that I'm seeing, even if mistakes